CitiDem series. And indeed, I'm extremely excited that we have Jón Ólafsson from the University of Iceland joining us this afternoon, discussing, I think, a topic that at least I myself have been excited about for a long time when it started happening, basically with the financial crisis, etc., and then the Icelandic reaction to that crisis. And it's really great, I think, to keep on discussing what remains maybe a bit of a mythicized process, but definitely a process that many have been following, in particular people interested in participation, in democratic innovation, and also in relation to something that I still find a bit of a niche topic, that is citizen participation in constitutional reform. And that makes it for me really a really interesting topic, and of course for Jón it's something more than a topic, being an Icelander, where it's actually part of a societal process of renewal or not. Just very briefly, for those of you who haven't been part of our webinar series yet, my name is Paul Blokker. I'm a professor of political sociology of the University of Bologna. And I'm coordinating a project that is funded by European Union SURF money, which is largely a civil society project in which we have been organizing a whole range of citizens' assemblies in various European countries. I'm actually organizing a rather big event in Bologna in a couple of weeks' time, where we organize a kind of transnational European Citizens' Assembly. Will be a daunting task. And so our interest is basically citizen participation, democratic innovation, and how somehow we could use things like what is now very popular, citizens' assemblies, to actually strengthen democratic societies, and so on. And so returning indeed to our specific episode today, which I think is an extremely important case, if you would want to call it like that in scientific terms. And we have indeed a really wonderful speaker, Professor Jón Ólafsson, who has been writing on the topic from the start, I suppose, basically. And indeed, many of us publications are giving us really interesting insights in the process of Icelandic reform, constitutional reform, the role of citizens in this. For instance, one of his publications of some 10 years ago now is The Constituent Assembly, a Study in Failure. Then another article is called, a chapter actually, When Experts and Crowds Disagree. And the trigger that actually led me to inviting Jón in our series was that I read a recent paper called Constitutional Reform Revisited, From Crowdsourcing to Stagnation, which I really found very interesting. And I think it also provides a whole bunch of insights that we may use beyond the Icelandic context, and that may be effectively also very helpful, not only for CitiDem in our project, but also for a larger coalition which CitiDem is part of, which is called Citizens Take Over Europe, where, and I see my co-conspirator here, Karsten Berg, where we, for years now, we have been organizing a working group on what we call the constitutional question. And Iceland pops up there pretty frequently as an example, as a topic, as something to learn from deeply. So I'm really happy that you're with us, Jón, also in the wake or in the run-up to Easter. I guess a lot of people have their minds already elsewhere. I for sure also am pretty much in for a rest, at least for a couple of days. Let me just say a couple of things about the format. So I keep people muted. You can open your cameras, you can write in the chat, but I prefer to keep people muted as long as Jón speaks so he can uninterruptedly make his argument presentation. And then I will just give a couple of comments, and we can open up for discussion and Q&A. And then, of course, everybody can unmute and contribute freely to, let's say, a democratic deliberation. So without much further ado, Jón, if you want to start, I guess some 20 minutes or even more if you want to, should be okay. And I'm really looking forward to your presentation. Thanks so much again for joining us.
Well, thank you, Paul, for inviting me and for the generous introduction. It's so the paper that we are talking about here, or I'm basing this talk on, is very much a work in progress. So I have written a few pieces on the different aspects of the constitutional reform process in Iceland. But I really want to write a sort of a bigger overview of that, which has not been done neither in Icelandic nor in English. So I'm kind of working on two projects at the same time, going a bit slowly, I must confess, but this is very much a part of that. And what I'm doing here is developing certain doubts and apprehensions maybe about the ways that a citizen project like the Icelandic constitutional reform process was, it isn't all that glorious necessarily. It can lead to political complications that eventually may really rather hinder reform than help it. So that's what I'm going to focus on in the paper, in the talk, and I'm very interested also in your comments and questions on this. So I take two cases to look at from the Icelandic process. On the one hand, a particular question which was very much, or has been very much, in the focus of constitutional reform in Iceland for a long time, longer than since 2010 actually, and it has to do with Iceland's main industry, the fisheries. And another question is, or another issue that I'm going to look at briefly, has to do with the way that the Constitutional Council, to begin with, defined or understood their task or their work. But then I'm also going to talk about how the activist movement has developed after, in the years since this process got stalled. But let me, even though I'm sure many of you have know a lot about this, let me just briefly comment on the process as a whole. So, I mean, it's actually amazing how much has been written about the Constitutional Council in Iceland, and I know people who think that it's been over theorized, so to say, but I guess it's because it was pretty inspirational. It was the first of its kind. It was, mythologized a little bit from the beginning, but it also did things that had really not been done before, like working in a perfectly transparent way. It looked as if it was also working without any interference from government, and to begin with, that was also the case. But although I would argue that this is not necessarily a strengthening part of the project as a whole, expectations were created, which probably could not have been met. But there was an impression of authority that this Constitutional Council had. Maybe also because it had known people in Icelandic society who were also able to create a very nice impression on the international scene for international media and things like that. So then there was also the process talked into a very common myth about Icelandic democracy, because there certainly was a sort of a democratic arrangement in Iceland in medieval times. There's rich medieval literature that also, to some extent, describes democratic arrangements and so on. So people found it very easy to think of Iceland being a very small country also, as a laboratory of democracy. But I think that in many ways we have seen that the small size may not be such a great a great thing to have. It doesn't necessarily make things easier or better. And then there was sort of this sort of mutual reinforcement. There was admiration from the outside, outside attention, outside discussion, admiration. And from the inside, a certain moral certainty, which got stronger the more the admiration and attention from outside was more focused. So there was this sort of subliminal thing, the new constitution, which has been also in itself has been sanctified to a certain extent. Just to give you a timeline, this all starts with the financial crisis of 2008, a decision to create a constituent assembly, which wasn't really seen in very radical terms to begin with. It was seen as something that had been in the discussion for decades, actually, because the Icelandic Republic used an old template, so to say. The constitution was to a great extent Danish. It was based on the constitution that Iceland had when it was still a part of Denmark. But then, when this was done, the 25 individuals who were elected, they took matters very much in their own hands. There was a little bit of a complication with an invalidation of the election results. So in 2010, 25 people were elected, but the Supreme Court invalidated the results, although there was the flaws were really technical in the process. But the Parliament decided that since no fraud had happened, whatever the technical flaws of the process, there was no need to elect the members again, so they reappointed them. So this is why we have a constitutional council in 2011 rather than a constitutional assembly or constituent assembly. But and this is, I think, an important part of the whole thing, because of this sort of debacle, they were left more alone than the constituent assembly would have been. So they basically they got some instructions, but they could decide to do what they wanted, and they decided eventually not to revise the old constitution, but to write a new one. Then there was a referendum on the results in 2012, and this is a very important part of the process. However, in 2013, the Parliament simply failed to really get a majority on this, did not vote on the bill, and it got stalled. The next government was pretty uninterested in this, and decided rather to continue discussion on specific amendments. There were amendment bills proposed in 2016, but not voted on. In 2019, there was a new approach tried with the help of a deliberative poll. There was considerable effort put into this by the Prime Minister's office, and a very interesting, in my view, actually I was part of organizing that deliberative poll, which gave us a little bit of a different results than what we got from the Constitutional Council. Then amendment bills were proposed, but there was actually no consensus, and a lot of activist work and activity opposed to what the government was doing, developing sort of the claim that doing something different than just adopting the constitutional bill from 2013, working with that to make that actually a constitution, was a betrayal of the people's will and things like that. But this continues, and in 2024, actually the government which is in power now plans to propose amendments to the constitution before the end of its term in 2028. So we have had, it's going to be 18 years of sometimes nauseating actually discussion. And the obvious question becomes, by the way, do you see me moving the slides? You're not always seeing the same slide.
No, I actually only see the first slide. So
Okay,
something is probably not working.
Yeah, so what do you see now? Iceland
We
in
can now see
process.
your screen. Yeah.
Okay, so I'm just gonna skip the play mode. So I'm gonna keep it like this. Okay.
Yeah, maybe if you could enlarge it a little bit because it's a
Yeah.
bit, at least on my screen, it's a bit small.
Yes.
Okay, excellent.
So this is better, right?
Yeah, this is okay.
I'm going to make this okay. So
Okay.
now
Thanks so much.
so I was not expecting you to. So I was giving you the timeline here on the slides, the thing I was going through. So we are now in 2028, or will be in 2028, and I actually, to tell you the truth, I find it highly unlikely that there will be any amendments proposed, because what has happened is really that the activist movement that got engaged very much after the process stopped has been able to make this very difficult. And I think the politicians' strategy now is just to wait for long enough for this to become to disappear, basically. I don't know how long they have to wait, but at least the constitution is not the issue now. So if I just give you a sort of a schematic overview of this, just very briefly, we have a draft in 2011, a complete bill produced by the Constitutional Council, which goes to the Parliament. The Parliament is supposed to do something with it. It has an obligation or a permission, depends on how we see it, to really complete the process and vote on a new constitution. There's a referendum which actually showed very strong support, not for a ratification of the document, but strong support for continuing basing constitutional reform on the document that the Constitutional Council produced. But the debates, where there was a lot of debates on the status of the bill, what it actually meant. It was changed, but there was also a lot of doubting of the quality of the draft. And actually, I think time has not worked with the constitutional draft. There was a lack of collaboration also between the Constitutional Council and the Parliament, which at the time was sort of part of their moral strength. They were outside of the structure. They were not working with the politicians, but imposing the people's will on them. And then, of course, there's the question of special interest, which I will address a little bit later, because there were really issues like natural resources, which were very much in the center of the debate. How the constitution should regulate the use of natural resources. So this ends in what we could call a political impossibility. It's simply, even though there is support, there is general interest for the project, it becomes more and more distant from the political reality of actually being pulled through. And that's where we stand now, actually. In 2019, there's another effort, which still is based very much on the idea that this must be done through that constitutional reform should be based on public engagement. So there was actually Jim Fishkin participated in this with the Prime Minister. We used his deliberative poll idea and actually followed his blueprint pretty well. He assisted us with that, but the interesting thing was that in 2019, rather than having the effect of bringing people together again on something that actually could be passed, on recreating a new sort of dialogue between the activist groups, the government, bringing in the public, both in a big survey and in a deliberative meeting, writing the reports that you expect from such an exercise, and actually, which is what deliberative polls do so well, sort of making it a little bit more clear what the actual public views on the fundamental issues in the constitutions were. This, in fact, led to a much increased activist activity against this effort. So this was rather seen to be an attack on the old constitutional project, an attempt to undermine what the Constitutional Council had done, and to actually betray the will of the people. And this, so in the activist groups who were fighting to preserve the spirit and the actuality of the Constitutional Council, they completely turned, you could say, against the idea of going this new way. There also came up interesting disputes about what to do in case the deliberative poll gave us very different results about what the Icelandic public seemed to want and what the Constitutional Council wanted. To give you an example of this, which I think is very interesting, the Constitutional Council had been very strongly recommended that referendums and civic initiatives be well defined and easy to accomplish as a matter of constitutional articles. But the Icelandic public was highly skeptical about that. And in the deliberative poll, this particular issue was downplayed a lot. So there you could see there was a sort of a conflict between a well-researched or well-brought-out public view, you could say, or public opinion, and what the activist group, which had its own agenda, of course, wanted, and it created a question of legitimacy. Was the Constitutional Council, was it more legitimate in a sense than what could be brought out via a deliberative poll and things like that? But still, in 2019, the idea was ownership is necessary, inclusion is good, that will work against the influence of special interest, and acknowledging that this should not be 2001, this should be 2011 constitutional process is a major inspiration for any renewed effort, and so on. But what happened was, as I said, instead of a government being able to pull through revisions of the Constitution based on what the Constitutional Council had done, based on, for instance, the papers produced around the constitutional proposal itself in 2011. This did not happen, and instead we had from 2019 a renewed effort, you could say, which with a very strong and very successful, and I would say, very smart social media campaigning, where, for instance, people would gather with signs like this: "We want the new constitution," and actually there was an effort to paint everywhere in Reykjavik on streets and footpaths and so on. The sentence, "Where is the new constitution?" So there was a sort of a theatrical and often very funny atmosphere around this, but it thoroughly undermined all efforts to say, well, the process of 2011 didn't really work. We have to do something else. Can we bring people together around another approach? And not only was that impossible to do, but the activist movement, even if it was not very big, it was able to make this discussion toxic. So for politicians or political parties who were trying to sort of suggest this way or suggest another way, neither were they able to gather much support. The prime minister, actually, who led this process in 2019, she basically gave up. She tried to get for discussion amendment bills for a few things in the constitution, some of them very important, but it all failed. So the interesting thing is, of course, why is this so difficult? Why does this become so complicated? I see that I'm sort of taking a little bit more time than I was planning to do. So maybe I should skip these general. So
Well,
let me just.
if I may say, Jan,
Yeah.
I fully enjoy this. So
Okay.
please take your time. We have time.
Okay. All right. So I'm so it's just I just wanted to maybe stop a little bit with this general question. We assume, and this was the general assumption in 2011, that citizen engagement, of course, it needs to be organized well and so on, that it improves democracy. But in the Icelandic case, we really get into difficulty about this. What exactly is the citizen engagement about? Are we talking about actually impacting or leading policies or policy changes? Are we talking about increasing the resources available for policymakers to understand what the public is concerned about, which is what the deliberative poll really offers? It doesn't offer much more than that. Or are we talking about or additional resources or additional ways to provide criticisms to those in power? Maybe adding sort of the civic dimension to the political discourse. For instance, for people who neither can identify with the activist crowd, nor do they see themselves as politically engaged, but they still want to be part of a political discussion. And of course, the discussion of the early 2010s very much has been, and it still is to a great extent, very much focused on the actual impact of policy, the actual policy leadership. And I think this is precisely what, where things clashed in Iceland. So we have, of course, the Constitutional Council, it was not randomly selected, it was elected. But the people who were elected very much saw themselves as not part of competitive electoral politics. And a lot of the work within the Constitutional Council was about this. We are all friends. We are working together. We are going to produce something unanimously, and that is actually what they did. But this also means that the sort of the anti-political stance is very, very strong. But on the other hand, this assembly, this elect assembly, it created with time an activist force with its specific agenda. And the agenda wasn't necessarily that interesting for constitutional debate or for the broader for the broader intellectual engagement with what the constitution is, what it should be about. Why is it important for Iceland to have an Icelandic constitution? Why isn't it good to have something that is that comes out of a common European liberal political development, like the originating in the Danish constitution and so on. So the discussion becomes very much focused on singular issues on the one hand, and on simply arguing that the document that was produced, in this case in 2011, going through some changes between 2011 and 2013, is in some sense that everything else than simply accepting this document as the will of the Icelandic people is a betrayal of democracy. So the dramatization of the discourse veils the actual interesting policy issues, whether political things or legal issues and so on. And this is what happened. And I'm going to give you an example which might be a little bit, well, it's a little bit narrow, but I hope you will see my point. So here you have a typical Icelandic scenery, the fishing boats in the harbor, and one of the things that has been debated, as I said, a lot in Iceland, is the question about the exploitation of natural resources. Of course, we talk about natural resources. This is everything. It's wind, it's water, it's the sea, whatever. But still, this discussion is very much focused on the fish. So since the early 80s, we have had a quota system which divides fishing quotas to fisheries who own the quota. So the system creates very strong companies who not only are able to catch the fish and have the equipment and opportunities to do that, but they actually owned the fish before they actually take it, so to say. Of course, this is well known in many different areas, but this has been the system in Iceland for close to 50 years now. And this creates, it has one beneficial effect. It does help with regulating the how much can be caught over the year, and to make sure that there's not over catching of the different fish stocks. But it also means that it's a great source of inequality. So that there's a certain oligarchy in Iceland, you could say, where the fishing barons they have a huge share of the profits of these natural resources. And there's been it's been a constant source of political debate and political discomfort, the way that the system systematically discriminates against those who are smaller or who lose quota. For instance, places, townships along the coast, they can lose all the quota, and that means they are really without any means. So this is the system. One of the big issues after 2008 was to make sure that the profits from the natural resources were distributed more evenly. And the Constitutional Council did not invent this, but it used a concept that had been in development for some years before, something called national ownership, And so natural resources that were not already privately owned at the time of the council were declared or would be declared national property, which meant that the constitution would demand that any government could only license this, giving for a full price of the exploitation of the natural resources. And what does that exactly means? What is full price? How is that different from a normal price? How is it different from a fair price? What does this actually mean? How can you actually use natural language to impose something that is entirely predictable on the actions of the government? So on the one hand, there was willingness within the Constitutional Council to write this article in a way that would actually work, which would eventually make the quota system not viable. But there was also a second issue which came from the times themselves, that the distrust of government, namely that the Constitutional Council tended to see the Constitution as a document that could fully lock the possible action of the government, so that they thought that with this particular formulation, that anyone who was allowed, who got the license to use natural resources, would have to pay the full price for it, would mean that the government could not in any other way give the resources to their favorite people or something like that. So, but this then leads to this particular constitutional issue leads to a very confusing public discussion, going much into semantics even. So you have various attempts to write the text of the clause that stipulates the national ownership of natural resources. So, for instance, just to give you 4 examples, so in a draft from 2009, this is before the Constitutional Council, there's a suggestion that this will be put in this particular way. The state exercises their custody and right of disposal and supervises the use on behalf of the nation as further determined by law. So here you can see the Constitution is not going to stipulate how natural resources are to be disposed of or are to be used, but this is to be done by law. This formulation then is rejected by the Constitutional Council, and here you have 2011. Here you have the formulation from the Constitutional Council, where they say governments may, on the basis of law, grant permits for the use or exploitation of resources or other limited public goods against full payments and for a specified reasonable period of time at a time. So this is really the point here. Then in 2016, there's one more attempt to propose an amendment, or actually a new article on this. So then you have, as a general rule, a reasonable fee shall be charged for permits to utilize natural resources and land rights that are owned by the Icelandic state or national property. So this is seen with great suspicion. Who will determine what is reasonable, and so on. And then the final draft of this in the proposals drafted in 2020, the granting of permits for the exploitation of natural resources and land rights that are national property or owned by the Icelandic state shall be based on law and shall be based on equality and transparency. The law shall provide for the charging of fees for permits for exploitation of profit. So again, this does not really specify exactly how these fees are to be determined. So what happens really is that you would think, if we just think common sense a little bit. So we have a constitutional process. We have a lot of very engaged, very prominent voices whose goal it is to improve the constitution, so to say. You would expect something like this, which is generally widely shared belief by the Icelanders, that this is a necessary thing. There needs to be constitutional amendment about this. You would think that this can be solved in some way, maybe not the perfect way, maybe not in a final way, but in a way that would at least create the constitutional article allowing this. But it hasn't happened because what the activist movement has been able to do is really always to undermine everything that doesn't fit the maximalist, you could say, formulation that they think is necessary, namely that the Constitution includes something that can fully determine what actions are possible on behalf, what government actions are actually possible. And when you say, well, maybe natural language doesn't really give you this power, doesn't give you this control, it's always going to be possible to dispute or to reinterpret, what a full payment is, how is that determined and so on. So this really is on the one hand about, the particular issue, but it's much more, I think, about the continued idea, which I would think is a little bit kind of a naive and maybe politically speaking, a not very interesting idea that what the Constitution is, that the Constitution is some sort of a document that the public can impose on the government to control it rather than the common ground where people come together to make decisions about common values, common policies, and so on. So I think this is an example of how the activist group and social media campaigning really has been able to defer decision about this matter and make it impossible for any government actually to step in and complete the issue in some satisfactory sense. So to this day, there is nothing in the Constitution about natural ownership of national ownership, of natural resources, even though there has been 90% support for that amendment to be made for many years. So of course you could say, okay, so what good does a public discussion do anyway? Maybe the Icelandic constitutional experiment and its consequences show us also the limits of activist-led public discussion. It is trapped repeatedly in assumptions that may simply be immune from expert and political criticism. This also comes from the fact that campaigning is a lot easier these days than it was 10 or 20 years ago. Not so large groups, especially I would say in a small country like Iceland, can hijack a political process or a political discussion and at least stop things, if not able maybe to do much more than that. We also see that sometimes, of course, there is in Chile, we had the idea to constitutionalize very radical and complex principles, So there's also, even if we're talking about the fish, there's also some conceptual depth and clarity needed, which in this case gets lost in semantic really quabbles, I would say. And then we have impasses that really have maybe to do with insufficient understanding. So in this sense, we might see ways in which citizen deliberation is not really efficient or useful, even if it might help understand priorities. And I would say, and this is also, I think, very important, at least that's one of the more important things for me, the general distrust or defiance against politicians, which is very clear in much current discussion of open democracy or deliberative democracy. Take Ellen Landimore's most recent book. I would say the distrust of politicians may undermine deliberation and political knowledge. Actually, I was going to talk a little bit about, and this is in the paper, which I find very interesting, but it's a little bit maybe, it would take me too much time to get into this. So maybe I'll just jump to the conclusion here. One of the things I think we see in the Icelandic post-constitutional council activist movement is a peculiar issue in this. I mean, it's in a way you have an activist movement which is seriously unpolitical. They do not see themselves. They see themselves as radical reformers in the sense of the constitution. And they see themselves as the defenders of a radical reform process which has been undermined by corrupt politicians. But is that really helpful to have this sort of this escape from politics? So the public engagement movement does develop this strong antipathy of politics and politicians as well. Based on, of course, flaws that we all acknowledge in electoral democracy. But I think in the Icelandic case, we see the shortcomings of abandoning political competition for open competition-free democracy, because instead of making it more, making it easier, let's say, for politicians to actually achieve useful and important reform, the campaigning and the activist movement has made it more difficult. So it's, there are actually qualities of competitive politics that make them vulnerable. I mean, politicians, elected politicians, they need something more. They need to have grassroots support, and it can't be relatively easy to make them look foolish or bad with successful grassroots campaigning. I also think that the overly strong emphasis on the epistemic qualities of non-competitive selection processes always tend to assume that knowledge trumps power. That if we abolish electoral competition, that has something to do with power as well. Negative elements of politics will fade away. Knowledge will win. But I don't think this is really so obviously the case. We see easily how new leaders emerge, people who are successful in campaigning, in the same way as we see that as a certain weakness of electoral politics, who are able to sway public opinion and so on. So I think what we have in the Icelandic case, and I'm going to end with that, the constitutional experiment really produced a different kind of political force. It created a platform for people who were outside of politics, but who had the means, were smart enough, charismatic enough, and so on, to provide a constant opposition, campaigning force, capable of blocking results. And of course, you could say, well, isn't that wonderful? Is that what democracy is about? But in this particular case, it really isn't. It's a reality that has prevented constitutional reform rather than helped it. So the result, in a way, a bit depressing, but I find it also extremely interesting. The result of these, soon to be 18 years of constitutional reform is maybe this, that you can end up without any results, even when your start is so well meant and in many ways so interesting as the constitutional experiment was. So I'm going to stop here. I hope this is not all too confused and quick, but I would be really happy to have comments or questions about this.
Okay, Jón, super interesting. Really, I mean, I could now, for half an hour, I think, ask you a whole bunch of questions, but that would be very unfair to the audience. But let me just shoot a couple of things, just maybe to open up the discussion in a way. One thing that I find really interesting in the paper is this emphasis on a kind of constitutional activism. So I suppose some members of the Constitutional Council turning into longer-term activists for what they see as a kind of purist, bottom-up, citizen-written constitutional document. And that brings to me all kinds of things. There seem to be affinities with a number of things there. There's, on the one hand, there seems to be a very strong belief in that the Constitution is of overriding importance, which is not unlike the position that many public law constitutional lawyers have of constitutional norms, etc. But at the same time, it seems to me they seem to be doing something which you would call, in other contexts, forms of populism, that is strongly counterposing the people, the pure people, against the corrupted elites. And so what the pure people produces is then to be taken with priority, because the corrupt elites are indeed corrupt. And so I find that really interesting. Also, the way you formulated that later with, it's a kind of minority mobilization that manages in a way to hijack the whole process until this very day. So I would be interested in also knowing a little bit more about whom are these actually. Is this the whole council? I don't think so. And that relates, I think, also to a question about how pure is the people status of some of the members of the council. In other words, isn't it true that some of the members of the council might also be seen as experts, as university professors? And so to what extent are they actually representing the Icelandic people in such a pure way as they seem to be claiming? So that's one thing I want to ask. Very briefly, a second one, a comparative constitutional lawyer would probably say, wait a minute, let's also take into account the amendment rule of the Icelandic Constitution, Article 79, which is one of the most dramatically difficult, creates one of the most difficult situations to actually amend the Constitution, with dissolution of the parliament in between and things like that. So that's also, I think, a component in what makes this actually a failure, because it's actually almost impossible to use this amendment rule in a successful way, particularly for an entirely newly drafted constitution. And then thirdly, and then I will give you the word, of course, Jón, and then we can open up. One thing you didn't explicitly mention, but it's related also to fisheries, is the now reopening debate on EU membership. And so there's a referendum in August on resuming the membership negotiations, and I guess fisheries is one of the most dramatically difficult things to agree on with regard to membership. So it would be interesting to hear also, what does this mean for constitutional change, and also because membership would need a constitutional amendment, etc.
Yeah. Well, thank you. About the activists, there are relatively few members from the original Constitutional Council who are still active in this struggle. I mean, I think many of them tacitly support their old comrades from the council, but there's just a few, 3 or 4, who have been active in this. The main sort of the central point of this activism has been the Constitutional Society, so-called, which was a group of activists and people interested in constitutional reform, founded maybe 20-25 years ago, something like that. And they have used this association very much, as their label, so to say. But then there have been, petitions. There was a women's organization who collected something like 2,000 people on a Facebook site to make certain claims and demands about constitutional change. Then there was when the Prime Minister in 2020 and 2021 wanted to propose amendments that were based on the deliberative poll that I mentioned earlier. They collected actually 43,000 signatures, no small number in a country with around 400,000 inhabitants, right? And then, but the thing is that this this is the nature of social media campaigning. You can very much decide yourself on the formulation and the understanding that you have people sign something very general, but then you give it a more specific interpretation, which has been precisely what was done. So they have managed successfully, I would say, well, at least successfully enough, to interpret general interest and general support as a support for the specific demand that what they call the new constitution be simply adopted. And the claim that in the referendum of 2012, the Icelanders de facto adopted that draft, which is not quite right in my view. I mean, it was an understanding that the basis, as a basis for further work, this was really appreciated, but not something that could be seen as an informal ratification. So I think it's a smallish group, but they have also been very very rich in the connection to the artistic community, especially. There have been composers and artists who have worked with them, and I think like the picture I showed just one picture of one of the demonstrations. I mean, they are very skillful in their presentation and the so I mean, it's been really fascinating actually to see how they have succeeded to provide this opposition to the government. It's just that when you think about it from a more deeper and a more commonsensical view of saying, well, after all, the point is really that it's necessary to make a few changes to the constitution. You understand that that's not the point anymore. The point is really sort of to be able to preserve what I would call the maximalist claim, that the nation decided this, corrupt politicians refused to do what the people wanted, and so on. So that, but there is a along the way there have been some, different kinds of developments as well. But generally speaking, I hope this gives you at least some idea of how this has been, coming out really. Now, the amendment rule, I think actually, of course, it looks very, very unassailable. You have to have two parliaments. So the rule is, in order to pass a constitutional change, amendment, or pass a new constitution, two consecutive parliaments have to approve of it. So you have first, at the end of one parliament term, you vote on whatever change you want to make. And then one of the first things that the next parliament does after elections is to vote again. But it isn't as bad as it seems, actually. You only need a simple majority, actually. So if you, in case you are not going through big changes between elections, it's highly likely that something that's generally thought to be good will be approved twice. I mean, this is not a big majority or anything like that. It's a little bit, so the idea in the, when this was made part of the Constitution 44, the idea was rather than to demand big majority, to slow the process down. So if you make sure that it has to be on the agenda through at least one elections, you make sure that it is talked about in a way that will, prevent accidents from happening or something like that. I think demands for, 2/3 or 3/4 majority actually might be bigger hurdles than this is. But it gives, of course, the parliament the main function, and that's, the Constitution now doesn't really require any participation of the public at all. It's entirely in the hands of the parliament to, legally speaking, to change the Constitution, and I think that's also one of the things that everybody or everybody, a large majority of people would support the idea that you always have to have some public involvement. You can't. This can't be only in the parliament. Then let me see. The third, the EU membership. That's a very interesting part of politics these days. The funny thing is, the interesting thing is that the Constitution isn't really so much on the horizon in that debate still. So what the Parliament has decided is that there's going to be a referendum, not on membership per se, but on the question whether the government is allowed to continue negotiating with the EU. The negotiations were already very advanced in 2013 when an anti-EU government just decided to stop them. So now what you see in the political debates is really a very strong effort by right-wing political parties, right-wing and right extremists, to make this as difficult as possible for the government. And rumors are that they're getting more and more advice and support from the US for this, because even if Iceland is apparently not officially on the agenda in the US, it's very clear that something is brewing about that here, and the Americans see that as the Trump government and its supporters see it as an important issue to make sure that Iceland does not join the EU.
Thanks so much. Okay, so I now provided the option for anyone to unmute themselves. So I'm looking forward to questions. I think there's still so much to be discussed. So if anyone wants to jump in, please go ahead.
Yeah, if I may.
Sure, go right ahead, Karsten.
Big thanks, Jón and Paul, for the entire event and for your presentation. First of all, I would love to hear if you have any polls on membership affinity of Icelanders, EU membership, how far people are ready to continue these negotiations and then possibly also the membership itself.
Mm-hmm.
If you have any polls, that would be interesting to hear. And would love to hear also how far you discuss that this will, in case you join the European Union, that this might have fundamental constitutional implications because your constitution will not remain the same as it is today. And then the other part, from what I understand, Icelandic constitution is very much based on parliamentary authority. You know, from what I know, at least traditional Western democracies rather would say that all power is derived from the people, that the people are the center, and in a referendum, the people are in the center of authority. And if I understood it correctly, in the 2012 referendum, you had a constitutional referendum that was not, well, on the constitutional roadmap, so to say, if I understood it correctly. And then the parliament did not adopt this. From my point of view, as a continental whatever thinker, this is quite unusual in a way, right? I mean, in that sense, I was a bit surprised that you did not make this a key topic of your presentation, that this seems to be the bottleneck where the constitutional process actually ended already in 2012. If the constitution is impossible or almost politically speaking, so difficult to change, and that if I may say so without being populistic, that the voice of the people is not being respected, then this is kind of surprising. And if I understood correctly from my research or for reading, is that there was already the first referendum in Iceland after whatever World War II or 1944 on the Icesave case, right? And we all know that to change the constitution is nothing you can engineer from a political scientist point of view, but it rather needs some sort of a constitutional moment, right? Where this emotions and rational rhetoric is both in the game. And I understand that this was the case when Iceland suffered so strongly from the banking crisis. So I guess when we talk about, and I mean here, Paul and myself, in the European EU context, we also wonder when is the right moment to fundamentally change the European constitutional treaties. Of course, we don't have a constitution per se, but it de facto is a constitutional treaty. I was wondering if you could explore this a little bit further. This pre-referendums on the Icesave case, because you had two, and then you actually said that according to current polls, you think that Icelanders don't like any more referendums, even though there was strong participation rate in the Icesave referendums, and they contributed, from what I see, strongly to the constitutional moment that actually led to the entire process. These are some of the questions. Sorry, these were many questions, but just to give you some reflection.
Right.
To be honest, I was in Reykjavik in 2011 just for one conference, and I felt really inspired to say we had this conference with Mr. Grimson, the president of Iceland, and Mr. Gnor, I'm not sure if he's still active, the interesting...
Well, he's become a parliamentarian now.
So. Oh, interesting. Great. No, he was a great guy to talk with. This is my first time after, what is it now, 14 years actually, that I speak to someone from Iceland.
I see.
But I would love to return at some point. Yeah, this is what is basically the parallel concept of ideas. What brings me to this webinar right now, constitutional moments, how can we contribute to them, and from both a rational and also an emotional point of view?
Yeah. I mean, these are, as you said, many questions. So maybe to start with the 2012 referendum. I mean, there was a so it was a consultatory referendum. What does that mean? Well, it means that it's non-binding for the government. But of course, I totally agree with you, and I think it's difficult not to concede that point, that it is very strange for the parliament, as the Icelandic parliament did, to simply totally ignore the results. They were rare. They were hardly discussed. I mean, there may have been an afternoon where they were up for general discussion, but that the government or elected politicians in Iceland at the time would take this seriously and say, okay, how, just address the question. What does that mean? What does that necessitate for the policies to be? Of course, it wouldn't necessarily mean it means the government has to do exactly what came out of this, and it wasn't very clear actually what came out of it. Just what was clear was that it was easy for any government to continue working on the draft, saying this is what the public wants us to do. That would have been the easy way to do, and then you determine how you're going to do this. You're still going to make the changes you feel are necessary on the draft and so on and so forth. But it was simply ignored. And you can understand that raises difficult questions. But I would say, I mean, I have myself written about this and argued the same both in polemical pieces and in sort of more scholarly work. That there's some obligation for the political establishment to react in some way, at least to say what they're going to do in response to this. But it's been a while, it's been almost 14 years, and I think to go back to it now doesn't make much sense. It made sense maybe 10 years ago or 8 years ago, but today to go back to it would be archaeology. You would have to. So that's really my point on this. But I should also say, if we are in the details of the process 2012, 2013, I can also sympathize with elected parliamentarians, with MPs, who may have been very supportive of the Constitution, because at the same time, there was quite a lot of scholarly discussion by legal scholars and political scientists, which were not, did not really come out well for the constitutional draft. So for an MP, the idea that this draft was seriously flawed was something that needed to be taken into account. So many people just became a little bit apprehensive, thinking, well, is it maybe a bad idea to pass this? Is this maybe flawed in ways that will create more problems than we solve? How can I, as an elected politician, really carry the responsibility for that? So it's but that said, I mean, it still remains, in my view, the case that just ignoring it is definitely not justifiable legally, politically, or morally. But then the questions about EU, the EU. I mean, the current constitution makes it difficult for Iceland to join the EU. It's still disputed whether the current constitution actually has clear enough language about international treaties and transfer of sovereignty and so on for Iceland to be constitutional about what it's doing right now. I mean, the most serious scholars argue that it is, but it's still questioned, and I think it might actually EU membership would change this discussion completely, of course. It might be helpful in the sense that it would make it possible to go back to a more healthy status, not to be stuck in the old Constitutional Council affair, but to say, well, this is a new situation and that has to be faced. But the thing is, so maybe I don't know how aware you are of this, but I mean there is a very simple question, very simple issue that tends to be the major obstacle for people to support EU membership for Iceland, and this is control over the fishing grounds around Iceland. And I think it's true, as many people said, whatever temporary concessions Iceland will get, whatever temporary control and so on, even if Iceland gets the fishery commissar or whatever, in the end, this control will go over to the union. So in a way, the opponents, they say the government is never going to give us what we need. We are never going to get the full unlimited control that Iceland must have. So I think the question about this is really going to be the interesting question, and I think currently we have relatively similar numbers on both sides, supporting and against, but there is a clear majority, I think 70% or something like that, supports restarting the negotiations. So the real questions, they will only come up once we have the negotiation process going, and especially once there is some clarity about how this treaty with EU, how this membership would look like. But people also say, well, this is a good time to join the EU because it's important at this point for the EU to get Iceland inside. So the EU might be willing to make concessions that usually are not possible, right? So we'll see.
Thank you, John. Just one question on the direct democracy point, because usually we have constant majorities over all Western democracies where citizens want to demand or want to have more direct democracy. And you have had these referendums with a large-scale participation rate in part, and now the Constitutional Council also proposed it. But now you said the citizens are against this.
Right.
How do you come to this assumption?
Actually, this is a very interesting part of the whole discussion that which I think reflects the fact that people who become democratic or constitutional activists and believe in democracy and want to have more participatory and personalized democratic choice, they may not be the majority of the population. So even if people are not opposed to referendums and think that referendums are an important part of democracy, they may feel that the thresholds need to be pretty high. So, for instance, the question has been, the sort of the simple aspect of the question has been how large a number of people can petition a referendum so that the government will have to have it. 10% was the threshold suggested by the Constitutional Council. And this was, debated a lot, in then various amendment proposals later. 15% was something that would have been, agreement could have been reached on that, but the more radical people didn't like it. But when you ask the Icelandic public, they'll say 20% or 25%. You might think, well, maybe they don't quite understand what this is about, but nevertheless, and even in the deliberative poll, I thought this was one of the things where I thought, oh, of course, you will have a deliberation about this. People will understand better, that you don't have to worry that there will be referendum every day, even if you have 10%. But it didn't change that much. I think, if I remember right, there was 20% was something that was the most favored threshold for a referendum. And there was also apprehension about the overuse of citizen initiatives, which I think is a very benign and not threatening thing at all. But it turns out, when you have the discussion about this, that people also think this might be abused or overused and want to have a threshold higher than 2%, maybe 5 or 10 or something like that.
Interesting. Thank you.
Yeah, thanks a lot. I mean, one thing that keeps on sort of coming up in my head is that, I mean, I think it's not unfair to say that the Icelandic constitutional experiment is completely unique in the sense that it was really ultimately a citizen's draft of some kind. And so I mean, if you say you think that the hijacking of the process by constitutional activists in Iceland has made Icelandic constitutional progress almost impossible, what would you think about the sort of the international dimension? That is, maybe a negative effect of the Icelandic experiment is also that the idea that you could write a constitution, that the constitution could be written by citizens themselves, is flawed as such. As many constitutional lawyers, by the way, have always said, any kind of expert in the legal sense will claim, well, it's much too difficult, etc. So, and maybe in relation to that, and this is a bit of a provocative observation. So if citizens are then not able to write a convincing constitution, for instance, the Icelandic one was criticized importantly by the Venice Commission of the Council of Europe. If it's not citizens, should we then trust AI to write our constitutions? As recently Richard Elbert has written a whole paper about, because AI would be able to scrutinize every constitutional document today and in the past, and might be able to tease out all the finesses of a well-crafted, technically speaking, wonderful constitution. So, yeah, I wonder what your views are on this.
Well, I think that there are two perspectives on that. I would not say, I would not say something like citizens are unable to do this. It's too complex, too complicated task. They can't do. They don't have the conceptual robustness and so on. I think it's more the question of power or of authority. So, and this goes back maybe to open democracy and Landemore's ideas. And the which I mean, she is also a very good friend, just like Fiskin. She has been in Iceland, and of course, as you know, if you've read her work, she often refers to Iceland. She idealizes it a little bit, but I have over the years developed, or my views have developed a little bit in a way, different, in an entirely different direction from Landemore's, because the point is that you cannot. It's the mini public, the civic assembly, the citizens' assembly. Whatever assembly we create, it is always managed by someone, and to think of it as entirely autonomous, that you can have an entirely autonomous form of open democracy, is, I think, simply impossible. There is, if you don't regulate it, if you don't acknowledge it, it's going to arise by itself. There's going to, if the power is lying there in the streets, someone is going to grab it. It's as simple as that. And I think the Icelandic example provides a little bit of a case study of exactly that. So if we think back to the start of the Constitutional Council in March or April of 2011. There was this invalidation of the results, right? Which meant that even though the parliament tried to minimize the damage and say, well, we're just going to appoint these people, they're going to do the same, but we'll appoint them. It also meant that the original legislation about this constituent assembly wasn't in effect. That was also invalid. So what the parliament did was to make a much simpler declaration saying the Constitutional Council is going to have this and this and this and this task, but if they want to do this differently, they can decide to do that. So basically, it gave them free hand, even though there were some directions. And this, the Constitutional Council happily jumped on that. So they said, we can do whatever we like to do. We're going to write a new constitution. And I think this is the source of the perceived autonomy and the rise of a sort of a movement around this. At the time, you could also, and I mean, at the time, this was exactly my view, and it still is actually, when you saw that the parliament, that the government was giving them a free hand, you could also draw the conclusion, okay, if they're giving them a free hand, it also means they don't really believe in the outcome of this. They're seeing this, oh, we have to do this, but it's not going to be, it's not going to be really, we are not going to have a constitution out of this. They didn't really believe this would work. So my view is really that I mean I'm no opponent of citizen assemblies, quite the opposite. I mean I really find this form of engagement extremely rewarding and rich and interesting. But we shouldn't. I think the lesson is we shouldn't think of this as a transformative democratic tool. It's an excellent way to engage people. But it doesn't, if you throw away the power of elected, institutions, and say, this is managed democracy, this is managed participation, and it cannot be anything else. So within that framework, I think there's a lot that can be done with it. But the idea that we can set this free and we will have more healthy politics if we have less competition, if we don't have elections and so on, I think that's, I would even be as provocative as to say a dangerous illusion, right? And the danger is very well manifested in the Icelandic case, in the deadlock, even if that's a small case and things like that. But that's also why I think the Icelandic experiment, while it is not as glorious and great as many people would like it to be, it gives us extremely interesting things to look at. Negative, of course, but also things that I think might be seen as likely in other contexts as well.
Wonderful. I could still go on for a couple of hours, but we're actually running over time. So I would say if anyone still wants to raise a question, please do right now. If not, I would suggest we start wrapping up. I would really like to thank you, Jón. Maybe we should have some follow-up seminar in the future, because I think there's still so much to be discussed. And I completely agree with you that it remains a fascinating case. And one thing we didn't really discuss fully, but I think Carsten, for instance, hinted at it, is what are actually the moments, the constitutional moments that might work, right? I mean, I remember I was also in Iceland in 2011, and it was sort of, I don't speak Icelandic, so I got my information from the Reykjavik grapevine and stuff like that. But I really sensed the idea of a deep moral crisis as a result of the meltdown, etc., which you also had in Ireland, by the way, I think around the same time, of course. And so the question remains, what is the role of this in actually creating an opportunity, a window of opportunity for actual constitutional reform? That then didn't work out, but And so that would also speak to your argument in a way that you can't keep on dragging on with a draft that has been drafted a long time ago. It doesn't really speak to the current times, maybe. And that's I saw a hand by Carsten. If you want to jump in, go
Sorry,
right.
you had just already such a good conclusion. But if I still may ask one technical or detailed question regarding, since you mentioned the citizens' polls and randomly selected citizen assemblies, from what I remember, there was this random element in 2011, right, connected to this Constitutional Council. But then you mentioned also another form of randomly selected citizen assemblies, if I'm right, and with Jim. Jim Fishkin. Was Jim also involved already in the first case, or did you change the methodology? I think he was not, right? So in how far did you change? And ultimately, I fully agree with Paul. I mean, citizen assemblies isolated is, I think, nothing anyone wants to propose, but rather to think in how far they can be embedded in electoral and direct democracy, indirect and direct democracy. I think that only then they can really make sense in terms of having a transformative effect, as you said.
Well, yeah, I mean, we actually I mean, this is also I should say this is also a disclaimer. I mean, I was involved a little bit in this decision making. It was I who suggested, to use the deliberative poll, and my argument was that this might be a sort of a medium way, something that could appease the more hostile politicians, but also provide a platform, a perfectly legitimate and interesting platform. So that was the thinking, and I mean, I didn't foresee, the opposition that came later. And I mean, this is I could, if you're interested, I could tell you a lot about this. I mean, I was running myself a sort of a research project, well funded actually, and some of the people who were active were also, PhD students in my project, and I thought, this was an excellent opportunity to bring together, civic activism, academia, and things like that. But that was not quite so simple, not quite. So I mean, the Fishkin part in this was really only in this 2019 deliberative poll, because he was very interested himself, of course, in Iceland, and expanding to one more country, very generous with his help and advice, and I think we actually did this. I mean, I was very satisfied with how we managed to do all this. There was we had very well results that that were really interesting and told us a lot about what people really think when they have this opportunity to as the deliberative poll does. But was there something else in your question that I'm not?
Yeah, I was particularly, there within the deliberative bubble, where also Helen is part, and Helen
Yeah.
are part of,
Yeah.
and myself as well, more on the activist side. There is, if I am not wrong, this claim from Jim that he actually claims that he has a real representative sample. That is, I mean, he always speaks of the interesting case in Mongolia, where
Yeah.
he says that this is actually, from a statistical point of view, really representative. And while others think this is maybe a bit exaggerated, whatever, but I was wondering in how far the methods were really different from the 2019 citizens poll.
Completely different.
Did he actually claim to have a really statistically representative sample of the Icelandic population, or was he rather less overclaiming?
Well, it was a representative sample. So we had, first we had a survey with 4,500 people. I think we had around 60% participation, so it was not bad. Then we had 330 people from people who had answered who were willing to attend the meeting. So that was also well within the limits. One thing we did, which Jim doesn't really like, was because we could see that there was an uneven, the age distribution was not entirely felicitous, and we could also see that there was more sort of liberal left-wingers than the others. This is totally to be expected, of course. So what they did, people in the Social Science Research Institute who did all the quantitative analysis there, they weighted the results. But that given, I think we had a very, scientifically pretty reliable results in that. Yeah.
Thank you. Interesting.
Yeah, we could go on forever, but thank you so much, Jón.
Well, yeah. Well, Paul, thank you. I mean, this has been a great opportunity to talk about this, and I mean, if you have any comments on the paper or want to get in touch, I'm more than happy to
Sure,
engage.
and I'm looking forward to what comes out of it, further work, etc. Keep us posted. And yeah, so I would say let's wrap up, but this will not be the last time that I hope we will be engaging on these things. Just to keep you in the loop, we will have a next webinar on Monday, 13th of April with Maciej Kizilowski, who is one of the authors of a book that came out with Oxford University Press, which is called Let's Agree on Poland, which in some ways I think links also to your discussion of the Icelandic case. In Poland, it's a bit more, even more problematic, if you would want to say, because the book tries to propose how to rethink the Polish constitutional framework after populist rule, constitutional abuse, as some would call it, etc. And so will be a slightly different discussion maybe, but still very much linked. So if people want to join, please.
Yeah, thank you. I'll really try to do that.
Okay. Well, thanks again, Jón. We'll keep in touch. Thank you for the great presentation, great discussion, and I thank the audience, of course, for coming out on a Friday afternoon, which is already difficult, but now with Easter looming, it's even more difficult, I suppose. So have a great holiday in between, and hope to speak to you soon again.
Thank you.
Thank you.
Bye-bye.
See you later. Bye-bye.